For today's story, we cover a motion to intervene in the Chad Daybell Lori Vallow case going on in Idaho, in which a woman has said that, yes, the public does have a right to all the court documents the court has been keeping secret in this developing cult murder case. Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you enjoy this legal education content, and today will be the day I earn that subscription. For today's story, we are dealing with a development in the Chad Daybell Lori Vallow case, a case that we have been following, but it's been a little bit difficult to follow because most of the proceedings have been kept secret by the court. Now, there is a right to a public trial. And for whatever reason, the defendants in the current case don't seem to be much bothered by the fact that most of these things are in secret. So the defendants don't seem bothered by it, but it is a right to a public trial also held by the public. So a woman has moved to intervene as a member of the media to say that, yes, these things should be in the open because, First Amendment and all the rest of it. So let's go ahead and cover this motion and see what it has to say. Let's get started with this. The intervener is a credentialed author and, for what it's worth, also a former attorney, although now retired, who is writing a book about the Daybell case. Therefore, she is a member of the media and is standing to petition this court to intervene for the limited purpose of challenging the court's decision for wholesale sealing of documents. The historic and unassailable right of the public and press to witness criminal proceedings and view court documents and records is often best described by Justice Louis Brandeis' statement that sunlight is the best disinfectant. Or as Ralph Waldo Emerson said, a gaslight is to be found to be the best nocturnal police. So the universe protects itself by pitiless publicity. That's very fluid for sure. Since its drafting, the United States Supreme Court has constantly recognized the Constitution conveys a presumptive First Amendment right of access to judicial proceedings to the public and press, finding that presumption of openness inheres in the very nature of criminal trials under our system of justice. The United States Court of Appeals for the Ninth Circuit, which includes Idaho, also has recognized a constitutional right of access to court records, noting that the public and press have a First Amendment right of access to pretrial documents in general. When considering whether a constitutional presumption of access applies to a particular proceeding, courts apply logic and experience test, also called the press enterprise test. In Idaho, access to civil and criminal court proceedings is also broadly provided for in the state constitution. Courts of justice shall be open to every person, and a speedy remedy afforded for the injury of every person, property, or character, and right of justice shall be administered without sale, denial, delay, or prejudice. That does sound nice. In addition, the Constitution of Idaho provides that in all criminal prosecutions, the party accused shall have the right to a speedy and public trial, to have process of court to compel the attendance of witnesses, and to appear and defend in person and with counsel. Although Idaho courts have not expressly recognized a constitutional right of access to court records, the Idaho Courts Administrative Rule, promulgated by the Idaho Supreme Court and grounded in First Amendment principles, provides broad access rights and procedural protections for the public. That rule provides the public has a right to examine and copy the Judicial Department's declarations of law and public policy, and to examine and copy the records of all proceedings open to the public. A court's decision to seal documents and court proceedings should be made sparingly and with due consideration, because such a decision hides critical information about the workings of the government and specifically the criminal justice system from the defendants, the victims, and the public. Proceedings conducted openly under the eye of public discourage corruption, graft, bias, and prejudice. Without the disinfection of public scrutiny, the American court simply becomes a star chamber. This is pretty cool. Filled with actions intended to please authorities rather than administer justice. In the case at hand, the public, including victims, cannot ascertain the case is progressing fairly because they have no access to half the documents and proceedings conducted in the case. Has made it somewhat difficult for us to cover. This is true. As a result, victims, defendants, and the public have no confidence going forward that it will be conducted fairly and transparency. There is no indication the court even considered the relevant factors because as the court did not conduct a hearing required by the statute to determine whether to seal records. Neither did the court document his findings on the record and in writing as the rule required. There's no proof the court considered whether exceptions to the rule apply. In fact, there's no indication the documents or material contain highly intimate facts or statements, the publication of which would be highly objectionable to a reasonable person. The documents may likely contain facts or statements the defendants and/or lawyers for the state and defense may find embarrassing. No provision in the rule permits court to consider that when deciding whether records to seal. There's also no indication that documents or materials contain facts or statements the court might find libelous. Likewise, there's no suggestion that the documents or materials contain facts or statements, the dissemination or publication of which may compromise financial security or could reasonably result in economic or financial loss or harm to any person having an interest in the document or materials, or compromise the security of personnel, records, or public property of the use of judicial department. So basically, yeah, the court has failed to do the findings required by law to determine whether to seal. And because the defense so far has failed to object, then everyone seems to be happy. The court hasn't even bothered to do it. But, there is a right of the public, or so the rules seem to suggest. And accordingly, so does the U.S. Supreme Court for that matter. The public's First Amendment right to access public records regarding this case has been violated. The court decided to seal documents without a hearing, without notifying interested parties, and without making written findings necessary to seal. The court made no effort to avoid sealing by using less restrictive means, such as redacting. So that would be one thing, like if the documents contain sensitive information, redact the sensitive information and publish the rest. The rule is clear that even where documents contain personal data identifiers, the remedy is to be redacted, not wholesale sealing. So yeah, sure, redact the personal identifying information, but don't seal the documents. The court's decision violates Idaho statutes and rules, and Idaho court administrative rules. To date, the court has not published any public findings indicating what privacy interest is being protected, how that privacy right predominates the public's right to disclosure, and what alternatives were being considered. Further, the court has not, under the press enterprise test, considered whether the place and process historically has been open to the press and general public, and whether public access plays a significantly positive role in the functioning of the process in question. Of course, pre-trial public access has always played a significant role in assuring defendants receive fair trials and competent representation. In fact, public access is at the very heart of it. Neither the court nor the litigants have provided evidence that actual damage or prejudice will occur if the sealed documents are unsealed. The state's motion to seal simply state the intention is limited to unduly prejudicial publicity. The fact that media is interested in the case and desire to report on it is not sufficient to prove defendants will be unduly prejudiced by releasing pretrial documents or opening pretrial proceedings, especially where venue has already been changed to a larger population center to facilitate finding an unbiased jury. So they already have determined the trial should be moved to a different venue, which is a pretty extraordinary remedy because of pretrial publicity. So, maybe there's no problem in releasing this information because we already moved it to find a better jury. The court has chosen to deny access to the entirety of documents and proceedings rather than examine whether there's less restrictive remedy. This is, after all, a death penalty case. It sure is. The court has previously pointed out that such cases are different and require heightened care and scrutiny. I mean, as a matter of practical reality, as the courts sometimes say, death is different. So they do treat it differently as a practical matter. Nowhere is that truer than in the case of sealed documents and proceedings. How can the public or victims be assured such a sensitive matter is being prosecuted appropriately and fairly without access to proceedings and documents? Moreover, that higher level of care requires the court take some time to fashion a less restrictive way to balance the rights of defendants and rights of the public. The court is responsible to ensure the protected patient health information, other sensitive personal information such as birth dates, SSNs, and financial information are protected. The court has neither the authority nor responsibility to hide information from the public because it might merely embarrass someone or otherwise tarnish their reputation. The court may not withhold information simply because some potential jurors may be incensed by the information or otherwise form an opinion. The case has already garnered international attention and primetime coverage. That it has, including from yours truly, Uncivil Law. There is no proof that releasing reasonably redacted documents and hearing transcripts will prejudice a jury any further. The court has neither the ability nor authority to keep the jury pool pristine, and the abhorrent practice of wholesale sealing of documents and hearings is harmful to the full administration of justice. I mean, it's obvious this poor person is a former attorney, retired, but they're writing very, very well. It's like, yes, there is processes, by the way, to make sure the jury is sufficiently untainted, right? You don't have to keep them pristine, and you certainly can't violate the First Amendment or any other amendment in order to accomplish that objective, right? So, you have a voir dire. That's what you normally do, and you've already moved venue to have a less biased jury. And so this jury pool is supposedly supposed to be fair, despite the massive amount of coverage this has already gained. Not only, of course, in Idaho specifically, where the trial is being held, but nation and internationally. It's a major case. It's major in the true crime circles in particular because of this case and its complex factual network, where this is where you want to get out the cork board with the 3x5 index cards and the string, because trying to figure out all the relationships between people is basically a nightmare. But yeah, it's garnered a lot of attention. But that isn't a good basis merely to seal everything. It's like, that's not how we do things. We're supposed to have open trials. Yeah. The legal presumption in both the Idaho law and U.S. Constitution is for release of court records, with the court sparingly applying exceptions to the rule. The court to date has been doing the reverse, sealing court records and waiting for someone to object. The court's actions dates violate the victims' and public's First Amendment rights. The wholesale sealing of documents does not comport with the law in Idaho, court rules, or the Constitution. The court is legally bound to find the least restrictive treatment of information to date that has been sealed. The remedy will require time and attention. First, the court must redact all sensitive information and all personal identifiers pursuant to relevant law. The court should further redact the name of minors and any documents pursuant to other rules. If closed hearings contain protected information, they should be appropriately reviewed and redacted. Once redactions are complete, the court should immediately order the documents unsealed. In the future, every time the court considers the sealing of documents or the closure of proceedings, the court should be required to notify all interested parties, then hold a scheduled hearing in advance, and make writings regarding finding the record must be sealed of the hearing close. The rule contains a provision for temporary production of documents until a hearing can be conducted. Thus, that brings us to the end of this motion to intervene in the matter of the Daybell Vallow trial. Yeah, and I'm all about this, man. I mean, there's a First Amendment right. And, not for least of reasons, Uncivil Law would like to cover this case in further detail. The court continuously sealing everything makes that a little bit difficult. And it's a case of interest to a lot of people. And I'd like to cover the case very much, please, because people would like to learn about it. And we should have the right to do that. And so I applaud this person for going to the court and saying, you don't have a right to restrict everything. Good on them. And I hope the court takes this motion seriously. There is a hearing currently scheduled, incidentally, in the very near future. So we'll see if the court is inclined to grant any of this. But for the moment, that brings us to the end of discussion of this case.